call for peace after that bombshell announcement with 6 police officers facing charges in the death of Freddie Gray. We're now joined by Baltimore trial lawyer Paul Mark Sandler. Thank you so much for joining us.
Pleasure to be here, Minnie.
Let's talk about the charges real quick first. We have a range of charges here, from second-degree depraved heart murder to misconduct in office and these kinds of things. So give me an idea what we're dealing with.
The range is broad. Usually prosecutors, when they evaluate a case, want to make sure they're inclusive, and oftentimes, from a defense lawyer's point of view, it's an overcharge, maybe to give room for some negotiation if there's going to be a plea deal, maybe to urge or persuade one of these defendants to plead out, testify
against the others,
and produce evidence that may be lacking. So that explains why they're broad. I mean, the depraved heart second-degree murder is intriguing because of the name depraved heart, but it really means extra gross negligence. I think law students are taught that if you raise your hand and shoot a gun at a train that's driving by and someone is killed, which would be a consequence, it may not be intending to harm someone or premeditated, but it's murder just the same. And the penalty is grave, so that's a serious charge. The other charges of misconduct in office relate perhaps to not calling the medics when required or when common sense would dictate, allegedly. And then there's that interesting charge of a false imprisonment, which is going to be interesting. It's a rare charge in the criminal world for the simple reason that oftentimes police do make mistakes and arrest someone that ought not to be arrested, but they're acting in good faith. So this is going to be interesting to see how it unfolds, that charge.
I found that interesting as well. We need to mention this is just the beginning, and we've heard the term indictment. These officers are not indicted at this point. They are charged. Talk about the difference there.
Sure. A prosecutor has discretion. Why discretion in charging or going to a grand jury? If a prosecutor, the state's attorney here, charges by criminal information, it's not necessary to obtain an indictment. It's an alternative approach. If the prosecutor wishes, she or he, whatever the case may be, can go forward and seek an indictment. If an indictment is not sought, then a procedure called a preliminary hearing takes place. What's that? That's a situation where the prosecutor, the state must show probable cause to detain the defendant. In a probable cause hearing, sometimes more evidence will be brought out than the prosecutor wishes, so oftentimes there will not be an indictment, and sometimes the defense attorney would waive the preliminary hearing because it may be too soon to talk about the evidence.
I see.
And after that comes, of course, an arraignment, and then motions filed by defense counsel. There may be a request for severance. There may be a request really to dismiss the case on the basis sometimes prosecutorial misconduct. One idea a defense attorney might put forth is that the prosecutor violated certain canons of ethics by over discussing the case, impairing the fairness of the trial. So there are a list of checklist, if you will, of procedures to take even before we get to a trial.
We're out of time, but real quickly, any idea how long this could all take? People need to understand this is just the beginning, and this is going to be a long process.
Years, and the first battle will be, can a fair trial be afforded in this climate? It's another day, another chapter.
I'm sure fascinating for attorneys to watch this unfold. Thank you so much, Paul Mark Sandler, for coming in.
Thank you.